I'm Doug Wolfberg.
And I'm Steve Worth.
We're EMS attorneys with Page, Wolfberg & Worth. Welcome to HIPPA TV.
Doug and I both spent years in EMS as providers and managers, and now as attorneys. We've seen EMS from the field and in the courtroom. Over the next 45 minutes, we're going to use those experiences to help explain HIPPA in a practical way.
HIPPA stands for the Health Insurance Portability and Accountability Act. It's a federal law that regulates the privacy and security of PHI, protected health information.
Protecting the privacy of our patients' information is one of our most fundamental responsibilities, whether we're a provider, a biller, a manager, or an administrator. Not only is protecting privacy a legal requirement under HIPAA, it's also an ethical obligation for everyone involved in healthcare.
In a few minutes, we're going to present several practical HIPAA scenarios that often come up in EMS operations. But first, we got to bore you for a few minutes to take a quick look at HIPAA and go over some important things you need to know to comply with the law.
Let's start with defining the phrase Protected Health Information, or PHI. HIPAA is completely centered around PHI and what we are and aren't allowed to do with it. Simply put, PHI is any information about a person's past, present, or future health care that either identifies the patient or could reasonably identify the patient. This includes not only the obvious things like a name or address, it also includes things like identifying numbers, birth dates, and other information that could be used to identify the patient. PHI can take any form, written, verbal, or digital, and even photographs and video can be PHI. Some obvious sources of PHI would be patient care reports, medical necessity forms, patient bills, claim forms, and records we receive from facilities.
HIPAA is pretty restrictive. You can't use or disclose a patient's PHI for any purpose unless HIPAA specifically says you can. This is true even for deceased patients. Patients' rights don't die with the patient. So we start with the basic rule that PHI is completely confidential, and it's only to be used in the situations that HIPAA permits. And it's important to understand that when an EMS provider generates a patient care report, well, that's patient information that's the property of your organization, not you personally. The organization is responsible to maintain the security and the confidentiality of all of its patient information. Individual crew members or other personnel shouldn't be making their own personal copies of patient care records or maintaining their own files of patient information.
Now that we've gone over the general rule that PHI is confidential and can only be used when permitted under HIPAA, let's look at the three main purposes for which you are allowed to use or disclose PHI without the patient's permission. Those purposes are treatment, payment, or healthcare operations. We refer to these as TPO for short.
Well, treatment means that PHI can be used for any purpose related to providing EMS or healthcare to a patient. Anytime that PHI is necessary for the care or treatment of a patient, HIPAA permits you to disclose it for that purpose.
Payment means that your agency can use PHI to file claims with Medicare and other insurers to get paid for the services it provides.
And operations means that your agency can use PHI for internal management purposes, like quality assurance or quality improvement, licensure, and similar activities.
And although there are no limitations on using PHI for treatment, there's a very important restriction that applies when using PHI for payment or operational purposes. And it's called the minimum necessary rule.
The minimum necessary rule says that when it comes to payment and operations, we can only use the minimum amount of PHI that is absolutely necessary to accomplish the purpose of the disclosure. Essentially, that means just enough information to get the job done and not more than what we need. In other words, if you don't need to use identifying information about the patient, then you shouldn't.
Here's a practical example. Before you could copy a patient care report for a quality improvement committee meeting, you'd first have to remove any identifying information, like the patient's name, address, and social security number. That information isn't necessary for quality improvement, so it needs to come out first.
Another HIPAA requirement is that we give a privacy notice to our patients. This tells patients about their rights under HIPAA and contains information about your agency's policies and procedures when it comes to privacy. It may seem like just another piece of paper we have to give out, but it's important. You need to make sure that every patient that you treat has received your agency's current privacy notice. That means that all new patients should get a copy, and repeat patients who have already received a copy of your notice should get a new notice anytime that your agency revises its privacy notice. And hey, if you're not sure if a patient has received your privacy notice or not, always err on the side of caution, just give them a copy. The way that you prove your patients have received the privacy notice is by obtaining their signature on a document saying they've received it. Whether it's paper or electronic, the form the patient signs to acknowledge receipt of your privacy notice is usually the same one that your agency uses for billing the patient, the patient signature form. Now, if there's a situation where the patient's under duress, or unconscious, or incapacitated, or in the midst of some serious medical emergency, don't worry about getting the patient's signature. Just focus on patient care. Your administrative personnel or billing staff can always obtain that signature later. Or if your patient can't sign because, say, of a physical or mental condition, you should also document the reason the patient was unable to sign your form. And if possible, you should obtain the signature of someone who can sign on behalf of the patient, like a legal guardian, a power of attorney, a family member who helps take care of the patient, or maybe even a representative of a facility that provides care or treatment to the patient. But keep in mind that most patients, well, they're physically and mentally able to sign the form. And obtaining the signature at the time of service, that's the easiest, quickest, and most efficient way to get this required signature. So EMS providers should be very attentive to getting the signature of the patient or their authorized signer at the time of service. Steve and I have both spent years in the field, and we know that most of the time it's possible to get that patient's signature. Oftentimes crew members simply fail to get it without any good reason. Make sure you capture that signature at the time of service.
HIPAA also gives patients many important rights over how their PHI is used. Your agency has a whole range of HIPAA policies and procedures in place to meet these requirements. Some of these patient rights include the right to access their PHI, the right to ask that it be amended if the patient believes it's inaccurate, the right to know what types of uses and disclosures have been made with their PHI, and the right to file complaints if they believe their HIPAA rights have been violated. Patients were also given new rights under some HIPAA changes that recently became law. One of these is the right to access their PHI in electronic format if your organization uses electronic patient care records. Patients also have the right to request that you not use their PHI to submit a claim to their insurer for payment, but only if the patient first pays their bill in full. Another patient right as of 2011 is the right to an accounting of all disclosures of PHI made for treatment, payment, and operation disclosures made from electronic health records.
And remember, all of these rights under HIPAA, they belong to the patient, but there are also times when a personal representative may act on behalf of the patient. A personal representative is determined by state law, but typically that includes someone like a legal guardian, a power of attorney, a parent if the patient's a minor, or the executor of the estate if the patient's deceased. Now, in those cases, the personal representative can exercise all of the patient's rights under HIPAA, and you should treat that personal representative just as you would the patient.
Your agency is required to have a whole host of written policies and procedures in place to comply with HIPAA. Your agency should make these policies available to you, and you should be sure to familiarize yourself with them. HIPAA also requires that your organization appoint a HIPAA compliance officer. This person may also be called a privacy officer, who is responsible for overseeing your organization's overall HIPAA compliance. Any questions you have about HIPAA should be directed to that person. If you're not sure whether you can use or disclose PHI in a given situation, it's best to talk to your HIPAA compliance officer first.
HIPAA also has new rules in place that require EMS agencies to notify patients if their PHI is breached. Any non-encrypted patient information that's improperly disclosed or that's breached in any way has to be reported, both to the patient and to the government, the U.S. Department of Health and Human Services. So, for instance, if an unprotected laptop with patient information is stolen, or a patient care report is lost, or say a spreadsheet of patient accounts is inadvertently sent to the wrong party, the organization must notify the patients whose information was breached, or was reasonably believed to have been breached. This means that all personnel, whether patient care providers, billing staff, supervisors, or managers, who know of or even suspect an improper disclosure of PHI, must promptly report that breach to your organization's HIPAA compliance officer so that the proper notifications can be made. Now, this is true even if your partner or coworker is the one who made that inappropriate disclosure. A code of silence simply isn't acceptable. The organization has to be informed so that it can meet its legal responsibilities to make the required notifications in the event of a breach. And I know some of you must be glazing over when we talk about legal requirements, but this stuff is critical to your agency's compliance with these very important laws. Your agency is required to have a policy dealing with breaches, and you should review that policy to get a better idea of your agency's new responsibilities and why immediate reporting is crucial. Knowing and following these policies can also help you stay out of hot water with your employer.
Now let's use some EMS scenarios to tackle some of the practical issues you may face in applying HIPAA in the real world. We're going to present each of these scenarios twice. The first time, HIPAA will be applied the wrong way. Then we'll rewind and go over the right way to handle these issues under HIPAA. So as you watch each of these scenarios, think about what the HIPAA mistakes might be and think about how you could do better.
I don't see numbers on any of these houses. Some of the mailboxes have names on them. Why don't you call the comm center and see if they know the caller's name?
No, you can't do that. It's a HIPAA violation to use the patient's name over the radio.
Oh, that's right. Well, let's keep looking then. We might have to get out and knock on some doors.
Remember, HIPAA permits any disclosures of PHI without restriction whenever it's necessary for treatment purposes. Hey, if you can't find the patient, you can't treat the patient. So if it's necessary for patient care to use a name over the radio, then use it. This would also include situations where you would be giving a report to the hospital while you're en route with the patient. If they need the patient's name to pull their records and prepare to treat the patient when you get there, then that's a permissible use too. Of course, if it's possible to use a telephone or something that offers more privacy than the radio, your patient's information would be better protected. But it is permissible to use the radio, even if you're giving the patient's name, whenever it's necessary for treatment.
Another important concept is the HIPAA rule on incidental disclosures. This says that it's not a HIPAA violation if you're making a permissible disclosure and other people just happen to overhear it. As long as you take reasonable steps to minimize those incidental disclosures, you've met your HIPAA obligations. So if someone with a scanner overhears a radio transmission with a patient's name, that is incidental to a permissible treatment-related disclosure and is not a HIPAA violation. Oh, and another thing, most comm centers aren't even covered by HIPAA in the first place. So that's another reason it's usually not a HIPAA violation on their part if they use a patient name on the radio.
All right, now let's go back. Let's rewind this scenario and see how it plays out when the HIPAA rules we've been talking about are properly applied.
I don't see numbers on any of these houses. Some of the mailboxes have names on them. Why don't you call the comm center and see if they get the caller's name?
Okay. County Medic 153, can you please give us the caller's name? I can only see names on the mailboxes, not numbers. That would really help us out.
Medic 153, be advised the caller's name was Smith.
Okay, County, I see it. Copy that. Show Medic 153 on scene.
As you can see, using a name over the radio when it's necessary to patient care is permitted by HIPAA. HIPAA should never be applied in a way that delays, impedes, or prevents patient care. Never.
This also holds true when transporting a patient to a hospital. HIPAA does not prevent you from calling into the facility to give the ER staff a medical report on your incoming patient. All of these radio communications are related to patient care, and they're permitted by HIPAA.
This would also be a good time to mention that this idea of incidental disclosures makes it permissible to put more than one patient in an ambulance. It is not a HIPAA violation to have two patients in an ambulance, even though one might overhear PHI about the other. This is the same reason that hospitals don't have to completely have private rooms. Sometimes patients overhear information about other patients. And HIPAA recognizes this, that sometimes this may happen in the course of providing medical care. Let's talk about disclosing patient information to law enforcement. This is a big issue that EMS providers deal with on a regular basis. And there are a lot of misconceptions about what EMS providers can and cannot say to the police.
Excuse me, I have a few questions for that patient if she's stable, please.
Sorry, I can't let you talk to her. It's a HIPAA violation. I do have to get going, though.
Allowing patients to disclose information on their own behalf is not a HIPAA violation. And also remember, HIPAA regulates the release of patient information by healthcare providers. It doesn't apply to the police. If a police officer speaks directly to a patient, it's the patient, not you, who's giving their medical information to the police. And that's not a HIPAA violation on anyone's part. So if you have a stable patient and treatment wouldn't be compromised by waiting a minute or two to allow the police officer to speak with the patient, it certainly is not a HIPAA violation to allow him to do so. Now let's look at this scenario again and see how it would play out when applying HIPAA properly.
Excuse me, I have a few questions for that patient if she's stable, please.
Sure, she's stable. We can wait a few minutes. Let me ask her if she wants to talk to you.
There are actually 6 different exceptions that allow EMS providers to share patient information with law enforcement officers without violating HIPAA. Now let's take a quick look at them. First, EMS providers can share PHI with the police whenever the law in your state requires you to do so. For example, if you're served with a summons, a subpoena, or search warrant, HIPAA permits you to disclose the information sought in those legal documents. Another example of being required by law to disclose patient information to law enforcement is when a state law mandates you to notify the police regarding certain types of injuries. Some states require the reporting of things like gunshot wounds, burns, animal bites, or other kinds of injuries. State laws vary, so be sure to ask your HIPAA compliance officer which requirements may exist in your particular state.
Now, the second law enforcement exception is that you may disclose PHI to the police to help them identify or locate a suspect, a fugitive, a material witness, or a missing person. Now, these are typically urgent circumstances we'd be talking about whenever the police need information to find one of those kinds of people. So HIPAA doesn't require that these kinds of requests have to be in writing. In these cases, you can only release certain limited PHI though, such as the patient's name, address, their date of birth or social security number, the type of injury they may have had, the date and time that you treated them, the date and time of death. And you can also give the police a description of distinguishing physical characteristics of the patient, like their weight, their height, scars, or tattoos they might have had.
Third, you can disclose to the police PHI about a person who you believe is the victim of a crime. Let's look at a scenario which deals with both the second and third exceptions, suspects and crime victims.
Hey Chris, how you doing?
All right, John, how you been?
Good, good. Hey Chris, I need to get some information on these 2 drivers from the accident, okay? Guy driving the white car is obviously a DUI, so I need his name and his injury status, but also the girl in the blue car. I got to get some information for her, and what I really need are their names and what type of injuries they have.
John, I'm sorry, but due to HIPAA regulations, I can't provide you with any of that information.
How am I going to get it? I need it for my report.
I don't know what to tell you. You can call Wendy at our office. She's our privacy officer. Basically, she's our HIPAA cop. We don't want to get a hard time from her about giving you this information.
Okay, I guess I'll give her a call then.
In cases where your patient is a crime victim, PHI disclosures can be made to law enforcement. Simple verbal agreement from the patient is all you need. Of course, you should then document that the patient gave verbal permission for you to disclose their information to law enforcement. If it's a situation where your patient is unconscious or can't give you permission for some other reason, and the police need the information immediately for investigative purposes, you may still disclose patient information about a crime victim to the police if you believe the disclosure is in the best interest of the patient and if the police officer agrees that the information won't be used against the victim. Now let's replay this scenario with the proper approach under HIPAA.
Hey Chris, how you doing?
All right, John, how you been?
Good, real good. Hey Chris, I need to get some information on this accident over here. The guy driving the white car is obviously a DUI, okay? So in order to file charges, I'm gonna need his name, but more importantly, I need to know his injury information.
Oh, since you're telling me you need to identify patient number 1 who is a suspect in a crime, I can tell you that his name's John Smith. He's 19 years old. He's got some minor trauma, mostly superficial to the upper body and a head laceration. We're going to be taking him to Community Hospital's ER here momentarily.
Okay, Community Hospital. All right. How about the young lady? I'm going to need to get some information on her too.
I don't know, since you're telling me she's a crime victim, I don't think I can really give you any information unless you first tell us you're not going to use it against her at all.
No, absolutely not. None of this information will be used against her. Like I said, she's strictly a victim here. In order for me to file the proper charges, I need her information. That's all it's going to be used for.
All right. Well, I'll tell you what. She's still in the back of the truck here. They're still working on her. Let me go ask her if that's okay with her, and I'll get back to you.
Okay.
Hey, John.
Yeah.
She said it's all right. She gave us her verbal permission to give you her information.
Okay.
Give that to you if you're ready.
Yeah, what's her name?
Name's Sally Jones. She's 43 years old. She has some injuries to her chest. A lot of right-sided injuries, possible fractured right arm, possibly fractured right forearm, and definite rib fractures. Also has a possible fracture to the right foot, which she said was caught under the pedal. Just due to that, we're going to be transporting her to Memorial Trauma Center here momentarily.
Okay, great. Hey, Chris, I really appreciate it. Thanks.
No problem.
Okay.
Fourth, HIPAA allows you to disclose information to law enforcement about decedents when it appears as if the victim died as a result of criminal activity. Now, you don't have to be a CSI investigator. You don't need to have legal certainty that a crime was involved. As long as you have reasonable, good faith belief, you may notify law enforcement anytime you believe a patient death may have resulted from criminal activity.
The fifth law enforcement exception is when a crime occurs on your premises. If a crime occurs in your station or in the back of an ambulance, such as an assault against a crew member, you may notify law enforcement to report the matter, even if it means disclosing patient information about a person involved.
Now, sixth, there's a general exception that allows you to report crime and emergencies, as this next scenario demonstrates.
County, please notify law enforcement that we're on scene just west of the intersection of 2nd and Main Streets with a male assault victim. The patient reports the perpetrator is approximately 20 to 25 years of age, white male, wearing a baseball cap, blue jeans, and an orange t-shirt. He reports that the perpetrator fled west on Main Street, apparently on foot.
So, as you can see, though HIPAA is strict in limiting the types of disclosures we can make when it comes to patient information, there are several exceptions that still allow EMS to work with law enforcement if it's under the specific situations we've discussed. But remember, at the end of the day, EMS providers are patient care providers, not law enforcement agents, and you can only share information with the police in these limited situations as we've discussed.
Now, there are two more HIPAA exceptions that are law enforcement related, but may also permit disclosures to other types of agencies, including law enforcement. First, you can notify appropriate authorities, such as police or prison officials, if it appears that an individual has escaped from custody. Second, where state laws require you to report instances of abuse, neglect, or domestic violence, HIPAA allows you to make these disclosures to the appropriate agencies that investigate these matters.
Let's talk about an important issue that seems to be coming up more and more lately, and that is disclosing patient information to the media.
We're here with Obi, one of the paramedics who treated star NFL running back Larry Scott after his car crash. Obi, what can you tell us about Larry's condition?
Well, Mr. Scott's vehicle struck a telephone pole on Route 28, just 2 miles out from the city. It was clear that he was under the influence of drugs, as he admitted that to me while we were treating him. His head struck the windshield. He suffered some facial injuries, a concussion, and possible broken leg. I don't know if he'll ever play football ever again.
Do you know what kind of drugs Mr. Scott was taking?
No, but I'm pretty sure they weren't legal ones with the way he was talking.
Well, that's it for now. Shocking news about NFL superstar Larry Scott. We'll have more for you tonight at 11. Back to you in the studio.
Well, clearly this EMS provider made a bad decision here. HIPAA strictly prohibits EMS providers from disclosing any patient information to the media. Even confirming the identity of a patient you think the media already knows is prohibited. Quite simply, HIPAA only permits disclosures of patient information to the media where the patient specifically authorizes it in writing. EMS providers simply aren't allowed to give out patient information just because the media asks. And remember, because of the new HIPAA breach notification requirement, the patient would need to be notified that this breach of PHI occurred under your organization's breach notification policies. Now let's look at the proper way to handle this same scenario.
We're here with Obi, one of the paramedics who treated star running back Larry Scott after his car crash. Obi, what can you tell us about Mr. Scott's condition?
Well, unfortunately, I can't tell you much of anything. As a healthcare provider, I'm bound by strict rules of confidentiality and ethics to respect the privacy of all our patients. I hope you understand this, but I just can't say any more.
Well, News 7 has learned that Mr. Scott was under the influence of illegal drugs at the time of the crash. The police also confirmed this. What can you tell us about that?
Again, I'm sorry, but I can't even confirm or deny anything you may have gathered from other sources. That would be the same as divulging patient information.
Well, that's the story here. Medical providers are being tight-lipped about the condition of Mr. Scott. As more information becomes available, we'll be sure to get that to you. Back to you.
As you can see from the second scenario, we can't give patient information to the media. And the medic was correct not to even confirm information that the reporter claimed to have received from another source. That could have just been the reporter repeating a rumor or fishing to see if she'd get lucky and hit the mark. Remember, EMS isn't supposed to be about getting your 15 minutes of fame. It's about caring for people, sometimes when they're in their most vulnerable, compromising, unflattering, or embarrassing positions imaginable. As EMS professionals, we come into people's lives at some of the worst times of their lives. Being a healthcare provider is a privilege. It's a privilege Steve and I enjoyed for many years. But with that privilege comes an ethical responsibility as well as legal obligations under HIPAA. Patient information simply isn't yours to give out. It belongs to the patient. Just because the media wants to know something, it doesn't mean we're allowed to give it to them. So maybe you won't get your face on television when all you say to a reporter is, "Sorry, I can't give you that information." But at least you'll have the satisfaction of knowing you upheld the law and the integrity of your profession when you do.
Very well said, Doug. And we're not just talking about national celebrities or sports superstars. The same rule applies when we're talking about people who may be well known right in your own community. A local politician, the bank president, and it really doesn't matter if the person is well known or not. It could even be the next door nosy neighbor asking what's wrong with the person next door. It could be a friend of yours asking how his uncle is doing. Quite simply, EMS providers are not allowed to give out this kind of information.
Well, we've covered a lot of turf, but we have some important turf left to cover. Another big privacy issue these days is the wave of social networking, blogging, texting, and tweeting that has swept over all of us. Smartphones and the internet allow all of us to stay in touch with the world, connect with our friends, and publish information to a wide audience anywhere in the world, literally in seconds.
But when it comes to protecting patient privacy, social networking, texting, and tweeting can pose serious challenges for EMS agencies striving to stay in compliance with HIPAA. Your organization should have written policies making it clear that your personnel are not permitted to disclose patient information in any fashion on any blog, website, discussion group, social network, or other public place. And this is true even if you think the information is de-identified. Simply taking out a name and address doesn't give us the right to post information about a patient. it's always possible that a friend or family member who lives in your community will know exactly who you're talking about. The internet has made the world smaller, and we simply cannot use it as a tool to talk about our patients or share their stories with the world. Posting stuff on the net is the same as gossiping about a call with your friends after work, except now the whole world can see it.
Hey Bill, what are you up to?
I'm just putting some stuff on Facebook about that call we had last night.
Really? What are you posting?
It was a gnarly trauma call that we had out on Highway 51. It was about midnight. That guy looked like road pizza. He was really mangled. They ought to really fix that road by mile marker 18. It is so dangerous. By the way, I didn't type in any name or any other patient information.
Oh, okay, sounds great to me. Yeah, they really ought to fix that road. Speaking of road pizza, when you're done there, you want to go get something to eat?
Sounds good. I'm starved.
Imagine how you'd feel if you were a friend or family member of the person who was hurt in this accident. While it's true that Bill's post didn't specifically use the patient's name, it provided more than enough information for friends and family to know exactly who he was talking about. It mentioned the highway, the date and time, and even the specific place where the incident occurred. Patient information doesn't have to identify the person by name to become a HIPAA violation. Not only that, but what you saw in this scenario, well, that's just plain unethical. EMS is going to lose the confidence and the respect of the public we all serve when people read us referring to patients as road pizza, or their conditions as gnarly trauma, or that they're mangled. These are words that we shouldn't be using, let alone posting on public sites. Now let's rewind this scenario and see how it should have been handled.
Hey Bill, what are you up to?
I'm just putting some stuff on Facebook about that call we had last night.
Really? What are you posting?
It was a gnarly trauma call that we had out on Highway 51. It was about midnight. That guy looked like road pizza. He was really mangled. They ought to really fix that road by mile marker 18. It is so dangerous. Oh, by the way, I didn't put any of the patient's name or other information in there.
Okay, you need to delete that post right away. First, it violates our HIPAA policy, disclosing patient information on the internet. Second, even though you didn't use the patient's name, people who know the patient can easily identify him from the information you provided. We don't use Facebook to post any information, period. We're going to have to notify the patient on this breach under our breach notification policy.
When it comes to social networking, texting, and tweeting, the easiest way for your agency to comply with HIPAA is simply to prohibit the posting of any patient or incident-related information in any manner, period. You should also make sure that your agency's website doesn't post any pictures, videos, or accounts of specific calls or incidents that might include patients, their homes, their vehicles, or any other information that could be used to identify them. It's not only a patient name or address that identifies a patient, it could also be pictures with the visible make or car color, buildings with street numbers in the background, or even images that don't show a patient's face but still show their clothing or other identifying features, perhaps a large tattoo. Remember, it's not our information to give out, it's our patients'.
Another issue that's related to texting and blogging is the use of cameras in the field. Almost every cell phone these days has a camera or a video recorder, and EMS providers may sometimes be tempted to use them during EMS operations. First off, remember that using cell phones can be a dangerous distraction when you're driving a motor vehicle, and your agency's policies should strictly prohibit that. But second, photography in EMS may have its place. For example, some EMS medical directors and emergency room physicians have asked EMS crews to try to capture images of accident scenes to help determine the mechanism of injury. Now, HIPAA doesn't prevent the use of cameras while providing EMS care, but remember that any images, video or audio recordings that capture identifying information, or even that could be used to identify the patient, all of that is protected health information, just like a patient care report or any other written document. And those images or clips should only be made on devices owned and issued by the organization, not on the individual's own personal cell phone. And the agency should store and control all of those files in the same manner it does for patient care reports. Individual EMS providers should not be permitted to make or keep copies of those images or clips for themselves because that's protected health information.
Another common situation that EMS providers face is dealing with family members of patients or other people who may be involved in their care. Contrary to popular belief, HIPAA doesn't prohibit EMS providers from sharing information with the patient's family members, relatives, close personal friends, or others identified by the patient as being involved in their care.
All right, you ready? Let's go.
Yeah, go ahead and go.
Hey, is that my wife? What's going on?
I'm sorry, sir. I can't tell anything about your wife's condition because of medical privacy issues.
But she's my wife. I'm worried about her. Is she having a heart attack?
Like I said, I can't get into it with you. You can talk with her at the hospital.
Can I ride with her in the ambulance?
I'm sorry, sir. It's a HIPAA violation. We got to get going.
HIPAA permits EMS caregivers to disclose patient information to a relative, a friend, or other person involved in the patient's care. This is also true even if it's someone who's merely helping the patient with their bills. It could be a friend, a family member, a neighbor, a power of attorney, or a spouse. HIPAA allows your organization to determine if these kinds of disclosures are in the best interest of the patient. But if so, you're allowed to share PHI with those individuals if it's relevant to that individual's involvement in the patient's health care. One instance, though, where you might make the judgment that these kinds of disclosures are not in the best interest of the patient might be where the patient's injuries may have been inflicted by the patient's spouse or significant other, which might be possible in a domestic violence situation. But if it's a situation where there's no suggestion that the patient's interests would be harmed by giving information to a friend, a family member, or a caregiver, then you're permitted to do so under HIPAA. And it's okay under HIPAA to let a patient's friend, spouse, or caregiver ride in the ambulance, but make sure that's something that's permitted by your own organization's operational policies and make sure they're buckled up. Now let's rewind this scenario and see how it could have been better handled under HIPAA.
All right, you ready? Let's go.
Yeah, go ahead and go.
Hey, is that my wife? Can you tell me what's happening?
Well, sir, we're not doctors. We can't make a diagnosis, but it's possible your wife's having a heart-related condition.
Can you tell me if she's having a heart attack?
Can't say for sure, but we have her on the heart monitor and giving her medications just in case. We're doing absolutely everything we can, and we're in contact with the emergency department doctor. She's in good hands, and we're going to get her to the hospital safely and quickly.
Can I ride with her in the ambulance?
Of course you can. You can ride up front, and we'll keep you posted on the way. Please make sure you fasten your seatbelt, sir.
Although HIPAA has many restrictions and limitations, sometimes EMS providers tend to read more into HIPAA than what it actually requires. HIPAA doesn't prohibit the exercise of good common sense, and it certainly doesn't seem to make sense that you'd have to completely shut out a patient's spouse from all information about the patient. As long as you determine that sharing information with people involved in the patient's care is in the patient's best interests, these kinds of PHI disclosures are permitted. You can also tell a friend or family member where you're transporting the patient or other information about the patient's location, as well as information about the patient's general condition, including if they passed away.
In these situations, HIPAA only requires that you obtain verbal agreement from the patient, or at least give them an opportunity to object. If they agree, or they're physically present at the time and don't object, then it's entirely permissible to share this kind of basic patient information with their family member or close friend. If the patient is physically or mentally incapacitated, then again, you need only determine if you believe the disclosure is in the patient's best interests, as Steve talked about a second ago.
And now we're really rolling along because here's another topic that's important. Let's talk about a few other common operational issues that regularly come up in EMS. First, let's talk about patient refusals. When it comes to a refusal of care or transport, EMS providers should thoroughly document the incident and the patient's refusal on their run report. Even though the call may not result in providing care or transportation, the incident should still be documented with as much information as possible, including the patient's name, address, condition, assessment, refusal, and other information. And the signature of the patient or their legally responsible decision maker should be obtained whenever possible. In these cases, your organization is still collecting protected health information, even though no care or transport was actually provided. This is PHI nonetheless, just like all of your other patient records. You should furnish or at least offer your privacy notice to patients who end up refusing care or transport, just as you would with other patients you transport, and make a good faith effort to obtain the patient's signature, acknowledging that they've received your privacy notice wherever possible.
Another issue is working with first responders and other EMS agencies on scene. Remember, HIPAA permits you to disclose any PHI for treatment purposes without authorization of the patient. So first responders and other EMS agencies providing care on scene may freely share patient information with your EMS agency, and you may share information with them whenever it's related to providing care to your patients.
When EMS is transferring care of a patient to a hospital or other receiving facility, it is customary to provide a verbal report and a copy of the patient care report to the staff of the receiving facility. These reports may be shared with any of the staff members who are involved in patient care, patient registration, or who perform other treatment or payment-related tasks. HIPAA doesn't say that you can only give patient information to a nurse or physician. If you give the information to a nursing assistant, registration clerk, or some other individual at the facility, that's perfectly fine. And HIPAA doesn't require that you give your verbal reports to the ER staff in some super secret private soundproof room. You can have a conversation in the normal places and speak in your normal voice, and you only need to remember to take whatever reasonable precautions you can to minimize the possibility of an incidental disclosure we talked about a bit earlier.
And the same is true when EMS is picking up a patient from one facility to transport them to another facility. Some facility representatives seem to be under the mistaken belief that EMS providers are not allowed to look at their patient records or other patient information, but are there merely just to give the patient a ride to the other facility. Some of these facility representatives may even tell you, don't look in that envelope, there's confidential patient information in there and it's protected by HIPAA. Well, it's true that an envelope containing patient records is protected by HIPAA, but remember that HIPAA allows PHI to be freely shared between healthcare providers who are treating the patient. And when EMS provides an inter-facility transport, certainly it's not just a ride to the hospital, it's the provision of EMS care and transportation. EMS professionals are healthcare providers who are involved in the treatment of the patient, just as the doctors, nurses, and other staff members of a facility. EMS providers are just as entitled to consult the patient's medical record for treatment purposes as are any other provider. And some of this information may also be helpful to your agency in obtaining reimbursement for the services that you provide.
Now let's bring HIPAA from out in the field into the office. Now folks, we're on the home stretch here, so stay with us. Now that we've spent some time talking about the privacy issues surrounding EMS field operations, let's talk about some important privacy, security, and confidentiality issues on the administrative side of your organization. Although the primary mission of an EMS agency is to provide emergency care and transportation to the sick and injured, that mission cannot be fulfilled without the critical support of your administrative personnel. These personnel include your agency's billing office staff, managers, the privacy officer, and other administrative personnel.
Well, now let's talk for a minute about a common scenario. Request for records from attorneys. EMS records are frequently needed by attorneys for litigation purposes. You know, the people like us, the lawyers that always want the medical records.
The ambulance chasers.
Well, we're legitimate ambulance chasers, but the other ones.
That's right.
Remember, though, that simply being someone's attorney doesn't entitle a lawyer to receive a patient's medical records. Ordinarily, when an attorney is representing one of your patients, such as after an auto accident, the attorney will normally send you a written authorization to release medical records, signed by the patient or the patient's legally responsible decision maker. And that authorization will specifically permit you to send the patient's records to the attorney's office. You should not release records to an attorney based solely on a verbal request. Make sure you receive a written authorization that's signed by the patient. Sometimes the attorney may instead use a subpoena or other legal document that compels you to release the PHI. Remember, if you're a field provider or a biller, these kinds of requests would ordinarily be channeled to your organization's HIPAA compliance officer. But make sure these requests are handled promptly and correctly, because HIPAA has specific time requirements for fulfilling these kinds of patient requests for records.
Another common issue is when people claiming to be patients call in for their medical records or to ask billing questions. Now let's look at a typical scenario.
Good morning, this is the billing office.
This is Helen Hodson calling. I was taken to the hospital by your ambulance on March 10th of this year.
Okay, yes, Mrs. Hodson, let me bring up your account. Okay, I have everything here on the screen. How may I help you?
I was looking over my bill, and I have a question on why I was charged for an EKG.
Okay, it looks like from the ambulance report that you were complaining of chest pain when our crew arrived, and they connected you to a heart monitor. And a heart monitor is the same thing as an electrocardiogram, so EKG stands for electrocardiogram.
It is certainly permissible, and in most cases even required, to share patient information with patients when they request it. If a patient or their authorized representative comes into your billing office to talk about their account, it's wise to ask them for identification and to verify who they are before releasing any PHI. And it's okay to talk to patients on the phone about their bills or regarding other questions they may have. But notice one key thing that the biller in this scenario didn't do. She failed to ask questions to verify the caller's identity. And then she proceeded to disclose patient information to the caller who just claimed to be the patient. Now let's look at how this could have been handled to increase the privacy protections for the patient.
Good morning, this is the billing office.
This is Helen Hodson calling. I was taken to the hospital by your ambulance on March 10th of this year.
Okay, Mrs. Hodson, could you give me your date of birth, please?
July 1st, 1932.
Okay, how about the last 4 digits of your Social Security number?
4035.
Okay, and one more thing, could you please confirm your billing address for me?
139 Walnut Street, Glenshaw, PA, 12345.
Okay, great. Now, how may I help you?
Now, as you can see, taking a few precautionary measures to verify the patient's identity before discussing their personal health information can help reduce the chances of a privacy breach from happening in the first place.
And another important thing to know about HIPAA from the billing side is that there's a new part of the HIPAA law that says patients can request that you not use their PHI to submit a claim to their insurance company for payment. But it's important to keep in mind that you only have to honor this request if the patient first pays their bill in full.
Well, now let's take a look at another scenario. Let's talk about one that deals with using computers and other electronic devices in EMS. These are becoming much more commonplace in use in EMS in the field, electronic data care reporting, handhelds, and other devices. Let's take a look at how a scenario like this plays out when we're talking about using computers and other technology in EMS.
Hey, what was that call you were just on?
Crabtree Drive.
Crabtree Drive. I think that was my uncle. He's been drinking again. Is he okay?
I can't tell you that.
Come on, you can tell me that.
Nah, you know better than that.
Computer-based PCR programs are great tools for writing complete and defensible run reports. But as this scenario illustrates, basic security precautions should be taken with regard to computers and other electronic devices when they are unattended. Every user should have a unique user ID and password. Security settings should be used so that each provider or staff member only has access to the PHI they need to do for their specific job. And devices should have automatic log-off features or should be turned off altogether when they're unattended for any period of time.
In addition to protecting patient privacy, HIPAA also has rules regarding the security of electronic PHI. So all our gadgets and gizmos, we got to take care to make sure that we protect the information that's on them. HIPAA requires that your organization have administrative, physical, and technical safeguards in place to secure your ePHI, or electronic protected health information. Well, let's cut through the gobbledygook for a minute. Administrative safeguards simply means that there have to be policies and procedures which need to be followed by all individuals in the organization. Physical safeguards, that's just the term that means your computer servers and your other important devices should be kept in secure places, like a room with a key code lock or other security. And the combination or the key should only be accessible to those with a legitimate job-related need for access to those devices. And technical safeguards, well, that simply means that devices should be configured with password security, automatic log-off features, backup capabilities, and other security measures. And it's important that members of your organization not do things that could jeopardize or defeat these electronic security measures. This stuff is common sense. Don't share your computer password with somebody else. Don't give the building or file room lock combinations or key to an unauthorized person. Don't download copies of any patient information onto a thumb drive or other portable device. It may sound like common sense, but everyone needs to do their part to protect the privacy and the security of electronic patient information.
We also want to address a few other HIPAA administrative issues. I know that sounds boring, but we're almost near the end, folks. Patients have the right to request that their information be amended if it's inaccurate or incomplete. For instance, you may receive a request from a patient to remove references to the fact that the patient was intoxicated or taking certain drugs.
Wait, you mean to tell me that some patients in EMS are drunk?
Perhaps so. You know, they're drinking something and taking something.
All my years in the field, I've never seen a drunk patient.
Yeah,
They've all only had 2 beers.
It's always 2 beers or 1 pill. The patient may have then subsequently been charged with a crime like driving under the influence and may want to have that information taken out of their chart so it doesn't get used against them. But HIPAA doesn't require a healthcare provider to amend records that are accurate and complete as they are written. So if you receive a request by a patient to amend their information, send that request to your HIPAA compliance officer. The compliance officer has deadlines and procedures to follow in responding to these kinds of requests. But remember, if the PHI was complete and accurate, you're not required to agree to the patient's request that it be amended. And your privacy officer can notify the patient that the request is being denied. In these cases, the patient does then have the right to submit a statement of disagreement to be made part of his or her medical record.
Whew, we've covered a lot of ground.
Gosh, we sure have.
Well, let's summarize what we've learned in today's training. First, HIPAA laws and regulations strictly limit the purposes for which EMS providers, administrators, billers, and others involved in healthcare may use or disclose a patient's protected health information. You must always act in a way that upholds the ethical and the legal responsibility to protect the confidentiality of your patient's information. PHI may be used for purposes of treatment or patient care. It may also be used for purposes of payment and healthcare operations, but only if the minimum necessary amount of PHI is used. Your HIPAA compliance officer is responsible to oversee your agency's HIPAA policies and procedures and should be your first point of contact for privacy and confidentiality related issues.
And when it comes to dealing with law enforcement, remember that there are limited specific situations where HIPAA allows you to disclose PHI to the police. These include situations where the police need to identify or locate a suspect and certain PHI disclosures about crime victims. There are several other law enforcement exceptions as well. In addition, extra attention needs to be taken when communicating with the media or when using social networking sites or other internet communications not to disclose any PHI that identifies the patient or even that could be reasonably used by someone to identify the patient. Quite simply, no texting, posting, or blogging about patient information, specific incidents, or other healthcare information should ever be tolerated.
And finally, remember that billers and other administrative personnel need to take extra precautions with regard to releasing, verifying, or even confirming patient information. Ensure that you verify the identity of the person you're speaking with prior to releasing any PHI to them. Ask them to verify information about the date, time, or place of service, or other information to help demonstrate that you're communicating with a person who really is authorized to receive PHI. And make sure that when fulfilling any requests for PHI from attorneys, you know those attorneys, that you have a written authorization from the patient or other personal representative, or that the attorney has a proper subpoena or court order for the records. Some of this stuff is complicated and confusing. Remember to talk to your privacy officer, and your privacy officer can always get a hold of us if they need help in understanding HIPAA and guiding them through what HIPAA permits and doesn't permit.
Well, we covered a lot of material today. Thanks for joining us. It brings us now to the end of our training. Remember, protecting the privacy, security, and confidentiality of all of our patient information is a continuous 24-hour-a-day job. And it's the responsibility of everyone in the organization, not just the privacy officer. Each of us has the professional obligation to respect the privacy of our patients and to protect their interests. And on behalf of all of us at Page, Wolfberg, and Worth, thanks for watching. And be sure to visit our website, www.pwwemslaw.com, for much more information about HIPAA and other EMS law topics.
So I was looking over my bill, and I have a lot of questions, but one thing
These
I don't
damn new
understand.
classes are for the birds. They are.
Oh, by the way, I didn't put in any name or patient information in here.
Okay. You need to delete that post right away. Sorry, guys.
She's my wife. I'm worried about her. Is she having a heart attack?
Tell him to shut up.
Donut.
I didn't know I was allowed to swear on this thing.
No, you can't swear.
Yeah.
That's a wrap.
Yay!